Good evening and welcome to LawCall on WLOX and WDAM. I'm Ken Flanagan. So happy to have you along on this stormy Saturday evening. We're here live in studio. We'll get you through this night, maybe get you to bed nice, safe and sound. We got a great topic tonight. We're doing one of our favorites, all about injury. Have you been affected by a personal injury claim? Maybe someone you know has been hurt by negligence or somebody else's fault. Maybe it was just an accident, but you don't know what to do. We've got the perfect show for you tonight. 896 Reeves, our friend, the Bulldog. Jim, good to see you again, my friend. You had a good President's Day, I trust.
Absolutely fantastic.
I'm going to ask you
I worked.
I'm going to. We did too. We did too. I'm going to ask you a President's trivia question at the end of the show.
Well,
just prepare yourself. Oh, I'm going to give you a heads up on there. A little constitutional law question. It'll be really hot stuff. Personal injury show, all about injury. This is really kind of, this topic.
Yeah, this is what we do, day in and day out at our firm. It's what we do. Well, I've always done pretty much all of my career.
Yeah.
And so we handle a lot of these cases. And when we're talking about personal injury, we're covering all kinds of claims, whether you're hurt on the job, whether you're hurt offshore, in a car wreck. If most people are involved in some type of legal action, it's usually going to be a car wreck or something like that over the course of their life. If you have an involvement with a civil litigation, it's almost always some kind of personal injury. And we've got somebody all the way from Gulfport to help answer the questions tonight. She's going to take all the hard questions. Chantrell Nix, my good friend from Gulfport who practices in this area and does a fantastic job, and we're glad to have her.
Ms. Nix, welcome to the show. In your office and in the legal kind of landscape here along the Gulf Coast.
What I've noticed, the major change is everything has changed since tort reform.
Yeah.
There's a limit on what you can recover.
Mm-hmm.
And also, it's harder to fight these insurance companies because they consider the coast as a conservative jurisdiction, which means that you have conservative judges, and it's harder to get your client compensated.
The insurance companies like it.
Absolutely.
Jim, we've talked about it.
Well, in average people, ask people, or the average person on the street, that think tort reform, caps on jury limits. Most of them think it's a good deal. It's not. Most people think that until they have a claim or have a family member who's involved in a serious claim. And you realize very quickly what it means is that individuals versus insurance companies and large multinational corporations get the short end of the stick. And it happens time and time again. There's some legislation I'd like to talk about that's recently been attempted to be passed up at the Capitol that's terrible. It's going to shield premises owners and business owners from liability, even if they know that criminals are on their premises or have reason to believe they're on their premises. It's going to make it so that no one can be compensated if you're assaulted or injured. So it's an ongoing fight.
Look what you have started, Chantrell. Right here. Look what you've done.
We didn't start it.
No, that's right.
That's right.
We're reporting.
Yes, that's right. Exactly. Yeah. Well, it is. It's wonderful to have somebody with your experience and your ties here on the show tonight. If you just joined us, our show tonight topic is all about injury, but it is now time for our email question of the week. Jim, this is an interesting one. It's from Lisa, and it says, I've started looking for a nursing home for my father. I was told by someone that I had to sign a form stating that I agree to arbitration instead of a lawsuit if there is negligence. Is this common? Jim?
Unfortunately, this goes along with what we were talking about earlier. It absolutely is too common.
Really?
It's you see arbitration provisions and all sorts of agreements now, and really in nursing home agreements, almost all of them this day and age have one. And it's unfortunate. This country, one of the great things about our country, unlike most places in the world, you have a right, if someone else injures you that's reckless or grossly negligent, to go in front of your peers in the community and have them decide whether they're responsible and should compensate you for it. Most countries don't have that.
That's right.
We in this country do, but arbitration agreements take that away. And they're in almost all the nursing home agreements now. You will see them, and you generally have to sign them if you're going to put your people in. That's right. Now, one thing I would talk about with nursing home neglect, and we see a lot of bad cases coming out of some of these nursing homes. Some nursing homes do a good job. But there's a lot of resources. Before you check a loved one into a nursing home, go online, go to the Attorney General's office. There are a lot of resources that rank nursing homes. You can easily access their performance record, how they've graded out, the number of complaints they've had, that kind of information, and you can at least make an informed decision before you put a loved one in a nursing home.
Ms. Nix, have you run into this with folks in arbitration agreements?
I have, not only in nursing home and also in the purchase of vehicles.
Really?
It's very, very common in every purchase agreement that you have to sign an arbitration agreement.
Is that like me and you were selling a car, or like with an auto dealership?
A dealership.
Get out of here.
Absolutely.
Almost always they're in there, and sometimes they're enforced. Most of the times they're enforceable. Sometimes they're not, but they're always unfair. A lot of times, some of these that are really onerous will require somebody in Mississippi to arbitrate in Michigan or some other state where the company is headquartered. It'll require people who want to arbitrate to pay for the arbitration, and so it's really an unfair proposition. Our Supreme Court has done a pretty good job of knocking some of these agreements down, but some of them are still enforced.
So, Santel, let's say I had an airbag problem with one of mine. I'd have to go to arbitration, then taking them to a...
No, that'll be totally different.
Oh, okay.
It's defective liability.
Yeah, defective liability. Yeah. We had one of those. We got the notice in the mail. Oh, man, there's a lot of airbag problems
What you typically
out
see is when you purchase. So if you purchase a vehicle generally from a dealership, you'll have an agreement in there that if you have a dispute over what they sold you, not being what you thought you purchased, that you have to, instead of taking your case to court, arbitrate with them. And so we're using this word a lot. I want to make sure everybody understands what we're talking about. Arbitration is basically where you sign a contractual agreement waiving your right that you don't normally have under the Constitution to a jury trial if you have a dispute with another party. And instead, it's decided by a panel of usually lawyers or former judges, or who are called arbitrators, decide the case instead of a local jury.
We help you. All right, y'all.
Hi, Lee.
Good evening.
Hey.
Good evening.
Yes, ma'am.
Well, I'm calling today. I had a personal injury done to me.
Okay.
It wasn't from a car accident or anything. This was from a food product.
Okay.
That broke my front tooth.
Okay.
I went so far as taking care of everything, what the dental bill would be. I even had anxiety because it took the front of my smile. At this point in time, I was speaking with an adjuster. He was acting like everything was fine, get all the information in to me. We'll settle this claim, we'll do everything. And then all of a sudden, he states that he sends me a letter, FedEx, stating that he didn't know if I had injury done to that tooth already or not. This front tooth of mine that was chipped off made it where I have to have a denture, and dentures are not.
Right, they're tough.
They're not cheap.
That's right.
So through the anxiety and everything I went through, it caused me to be hospitalized for 5 days. I went in there for one thing, but the anxiety that I had, which my medical doctor knew, I complained about my mouth.
Right. And
at the time, I was in his office speaking with the adjuster on the phone. My doctor even turned around and was very upset about the adjuster asking me to go around getting papers for this and papers for that. He says, you don't supposed to run around. Whatever he needs, he's supposed to request for it. Right. He says, I'm going to give you the name of an attorney. Well, at this time, the adjuster was...
Miss Lee, I'm so sorry. We're going to keep you on the line there. We are up against the clock a little bit, so I wanted to turn this one over to Jim. That way we have plenty of time to talk about this. Jim, it sounds like she bit into a product. There must have been something very hard there, and then her tooth.
So look, this happens more often than you might think, okay? And so the critical thing, the first question is, I don't know how long ago this happened, but you're going to have a statute of limitations, a limited period of time as to when you can bring a claim. So generally that's going to be 3 years from when it happened. So don't, if you're trying to handle this on your own, don't let that drag on with the adjuster before you go see an attorney if you have a serious injury. The second thing to remember, if you're dealing with something like this, it's the most critical thing to do is preserve whatever it was that injured you. Make sure you've got the can that it came out of. If you can identify the product. It's awfully hard a lot of times to identify some of these things, 6 months later. So all that's got to be preserved. That's usually the toughest part of this kind of case. And then finally, the pre-existing part, whether you had a previous problem with your tooth, probably could pull old dental records and compare those and determine whether you did or didn't have a problem before. But look, this sounds, a lot of people will hear this and it sounds on its face like it's not, maybe it's not much to it, maybe somebody should get over it. But if you had it happen to you, it's potentially a problem. And if the adjusters talk to you this long about it, you've had this kind of problem, you're entitled under the law to compensation. And I would I would actually call an attorney Monday morning, talk to an attorney about it. Attorneys who do this kind of work, my firm included, will talk to you for free. It may be that you have a claim, but it's not an economically viable claim to make a big lawsuit out of, but you may can bring it to in small claims court.
That's
so, but you have remedies available. Don't sit on them too long because the clock is ticking. Okay?
Ms. Nix, you're writing a book over here. What are your thoughts?
I was just writing, number one is when did the accident happen and how long did she talk to the adjuster? And just to make sure that she pursues it immediately, even though they have denied the claim.
Right.
That's right.
Now, would it be one of these things, Chantrell, does the clock start from the time her tooth got injured?
Absolutely.
Okay, so the clock is running at that point.
Yes.
And she's got 3 years. Can she do this on her own, or does she need an attorney?
Well, if you noticed early in our conversation or a question, she said the adjuster was very friendly.
Yes.
And that she thought that
she did say that
he was going to settle this claim and he was going to take care of it. A lot of times people assume that they can handle this on his own. And I'm not saying that because you and I are lawyers. You need an attorney to represent you. I mean,
that's right.
Those adjusters can be very charming,
well,
Jim.
Look, what people don't understand is the adversarial nature of this thing. So if you're dealing with an adjuster on the other side, his job is to save his client money, not pay you what you're entitled to.
Rachel, thank you so much. What can we help you with tonight?
Hi, Rachel.
Hey, what I was calling about, I had knee surgery back in February of 2017.
Okay.
And after the surgery, it was, I guess, about 6 or 8 weeks after that, I fell. My knee had given out on me, and I broke my wrist from that fall and had to be plated back together. Then after that fall, I fell again and tore my shoulder up. Well, at that point, insurance was wanting me to go get a second opinion on looking at my knee surgery again, and told me I need to get a second opinion to see what needed to be done. Well, the doctor I went to said that it wasn't done right, that it needed to be totally replaced again. So that's what I had to go through. I didn't know. I was just wondering if there's any kind of legal.
Sure. Rachel, great question. Sorry to hear about all of this. Let me throw it over to Ms. Nix first. What are your thoughts?
You certainly may have some ramifications from what you're saying is an improper knee surgery. My concern is, number one, when did the negligent act occur? Because that's when the statute of limitation begins to run. And many times it's 1 year or 2 years. It just depends on who the provider is and who the action is against. So I would say to you, being that this is 2019, you immediately need to seek legal advice.
Okay.
That's the first step. But I would have to, or some other attorney would have to review your medical records to actually see what, if anything, negligent we see in it. And a lot of times what we have to do is we have to hire an expert that would actually review the records and say that the doctor or the hospital breached the medical standard of care.
Okay.
Jim, what are your thoughts?
Great points all that Chantrell makes. The statute of limitations is the most critical one in a medical malpractice case. But it wasn't clear, I don't know if Rachel's still on the line.
She should be.
Was this initial surgery a knee replacement?
Yes.
Okay. So
total knee replacement.
So it's a couple things going on here. One, as Chantrell said, especially if the second doctor indicated to you that the first procedure was done improperly, someone needs to look at it, some lawyer who handles these kinds of cases, and look at it quickly. That's a strong indication that, you've already got one opinion by somebody that it's likely something that went wrong.
That's a good point.
The second sort of aspect of this, there are a lot of, and you see them on TV late at night, and we handle a lot of these cases. In fact, I'm handling a multi-district litigation in Baltimore, Maryland now involving defective knee replacements. And so the component part may have a problem. It may be subject to a recall. So you have two potential cases, potentially. One, for the doctor, if it was an improper procedure or surgery. Two, a separate potential claim if it is a defective knee product. And Chantrell is exactly right. The only way to determine this is to get it to an attorney who handles these kinds of cases. They can review the records and determine whether you have either case. And so you need to do that, though, as quickly as possible. It takes time to get the records, time to have experts to analyze them. You cannot wait to the last minute. We'll be glad to talk to you Monday if you want to call Rachel, but you need to call someone quickly.
Chantrell, a few minutes ago we were talking about the tooth, and Jim was talking, y'all were talking about there was a 3-year window on this one. Obviously, you're talking 1 to 2 year window. Something's changed here. Is it because of a doctor? It tightens up then?
Yes, so it's medical malpractice versus negligence.
I see.
So that's the difference.
That's the reason it tightens up on that.
That's right.
That's
right. And even to get, not to get too in the weeds, but if it's a state provider, if it's a community hospital,
which
it
we
could
have
be short,
this
it could be as short as 1 year.
Right.
So generally 2 years for medical malpractice, generally 3 years for other kinds of cases, could be as short as 1 year if it's a state or community-owned hospital.
Miss Nick, she needs to call somebody, doesn't she?
Absolutely.
So that means the show's almost over. Thank you so much for everyone who called in tonight. So sorry we couldn't get to everybody's calls. Call us back next week. But until then, good night.